He laughed at the wrong person. This 14-year-old murderer sat in court, watching his victim's parents cry, and smiled like he'd already won. He killed his teacher in a school bathroom, planned every second of it, wore gloves so he wouldn't leave prints, then acted like being young meant he'd get away with it. His lawyers promised the judge he was just a confused kid who deserved a second chance. He believed them, sat there calm and cocky, waiting to hear some soft sentence he could smile through. But then the judge started speaking, and suddenly that smirk disappeared, because what came out of that judge's mouth changed everything, not just for this killer, for the entire justice system. If you believe monsters don't get to hide behind their age, smash that subscribe button and tell us what you think below, because this case will leave you speechless. Let's go back to the beginning. October the 22nd, 2013, Danvers, Massachusetts, a quiet town where parents felt safe. Colleen Ritzer was the kind of teacher kids actually liked, 24 years old, always smiling. She'd stay hours after school ended just to help one struggling student finally understand math. Her classroom walls were covered in student artwork and motivational quotes. That Tuesday, she stayed late again, normal for her. But Philip Chisum stayed late too. He was 14, just transferred to the school a few weeks earlier, seemed normal, played soccer, decent grades, nobody suspected anything. But that afternoon, he came prepared. Gloves in his pocket, a box cutter hidden away. He followed Colleen down an empty hallway, into a bathroom. The security cameras caught everything except what happened behind that closed door. By midnight, Colleen was dead, and Philip was in handcuffs. The air inside Essex Superior Court carried a specific kind of tension that morning. February 26, 2016. Nearly 2.5 years after Colleen Ritzer's murder. The wooden benches in the gallery were packed with people who had waited a long time for this moment. Colleen's family sat in the front rows. Her father's hands were folded tight. Her mother sat perfectly still beside him. Behind them were former students, teachers from Danvers High, community members who remembered Colleen's smile. And at the defense table sat Philip Chisum, 17 now, older than the boy who committed the murder, but wearing the same expression he'd carried through every court appearance. Calm, detached, like he was watching a movie about someone else's life. His lawyers sat on either side of him. They'd spent months building a case around his youth, brain development research, psychological evaluations, Supreme Court rulings about juvenile sentencing. They believed they had a shot at a lighter sentence. And Philip believed it too. The proceeding began with the victim impact statements. This was the family's time, the moment the court set aside for the people who survived Colleen to speak directly about what her death had cost them. Tom Ritzer stood first, walked slowly to the podium. He held a piece of paper, but his hands shook so badly he could barely read it. He talked about his daughter, about the little girl who grew up wanting to be a teacher since she was 8 years old. About the young woman who came home excited every Friday to tell stories about her students. About the empty chair at their dinner table that would stay empty forever. His voice cracked multiple times. He paused to collect himself, and the courtroom listened in absolute silence. This was sacred ground, the one moment in the entire legal process that belonged entirely to the family. Everyone knew that. Everyone respected it. Everyone except Philip Chisum. It happened during Peggy Ritzer's statement. Colleen's mother had stood up after her husband sat down. She spoke more quietly than Tom had, but her words carried just as much weight. She talked about the daughter she raised, the kindness Colleen showed everyone, the way she'd call home just to check in, the plans they'd made that would never happen now. And then Peggy did something that took tremendous courage. She looked directly at Philip Chisum, spoke to him, asked him if he understood what he'd taken, if he grasped that Colleen wasn't just a name in a court document, but a real person with a real family who loved her. The question hung in the air, and that's when people in the gallery saw it. The corner of Philip's mouth moved, just slightly, but unmistakably. A smirk. right there in open court, while a grieving mother begged him to show some humanity. The reaction was immediate. You could feel it ripple through the room. Colleen's family saw it. The prosecutors saw it. Journalists in the second row saw it and made notes. Court officers standing along the walls saw it, and Judge David Loey saw it. He was sitting elevated at the bench, so looking down at the courtroom with the controlled attention of someone who'd presided over hundreds of cases. He'd been trained to maintain neutrality, to not let his personal feelings show during proceedings. But something shifted in his expression when that smirk appeared. His eyes locked on Philip Chisum. He didn't say anything, didn't interrupt the victim impact statement, but everyone who was watching the judge in that moment saw his jaw tighten, saw him lean forward slightly, saw the exact second when whatever small mercy he might have been considering disappeared completely. Philip Chisum had no idea what he'd just done. That smirk wasn't a nervous tic. It wasn't a misunderstood emotional response. It was contempt, pure and visible. And it told the judge everything he needed to know about who was sitting at that defense table. All the psychological evaluations in the world couldn't explain away what everyone had just witnessed. All the arguments about adolescent brain development couldn't erase the image of a teenager smirking while a mother grieved. The defense attorneys noticed it too. You could see it in their body language. The way one of them leaned over to whisper urgently to Philip. The way Philip's expression finally flattened back to neutral. But it was too late. The damage was done. That single moment of visible contempt had just sealed his fate in ways his lawyers would spend years trying to appeal. The courtroom had seen plenty of defendants over the years. People who cried, people who apologized, people who sat stone-faced and said nothing. But this was different. This was a 17-year-old who'd been 14 when he murdered his teacher. You who'd planned every detail, who'd shown no remorse through 2 years of legal proceedings, and who'd just smirked at a grieving mother in open court. It wasn't just that he'd killed someone, it was that he didn't care. Not during the crime, not during the investigation, not during the trial, and not now, facing sentencing with a judge watching him from 10 feet away. The psychology reports had used clinical terms: callous unemotional traits, lack of empathy, predatory behavior patterns. But the smirk translated all of that into something everyone in the room could understand without a medical degree. Judge Loey let the victim impact statements continue. Every family member who wanted to speak got their time. Students sent written statements that were read aloud. Teachers from Danvers High described what Colleen's classroom had meant. The statements went on for over an hour. And through all of it, Philip Chisum sat with that same controlled composure. No tears, no visible emotion, just the flat, detached presence of someone who seemed fundamentally disconnected from the weight of what was happening around him. When the last statement finished and the judge called for a brief recess before sentencing, the gallery stayed silent. People stood slowly, stretched, but nobody really talked. There was nothing left to say. They'd all seen what they needed to see. Now it was the judge's turn. Philip Chisum stood when the court officers approached, got escorted out for the recess. He walked past Colleen's family on his way to the side door, didn't look at them, didn't acknowledge them, just walked through like he was leaving a classroom after a boring lecture. And in that moment, watching him disappear through that door, everyone in the courtroom understood something fundamental. This wasn't a case about a confused teenager who'd made a terrible mistake. This was a case about a predator who'd worn a teenager's face while planning and executing a murder. And the sentence that was about to come would have to reflect that reality. The judge had seen enough. The evidence had spoken, and that smirk had said everything the defense had spent 2 years trying to hide. Before Philip Chisum became a name in court documents, before the surveillance footage and the forensic reports and the trial that captivated Massachusetts, there was just Colleen Ritzer. 24 years old in the fall of 2013. Now, a math teacher at Danvers High School who made algebra feel less like torture and more like something students could actually master if someone just explained it the right way. She wasn't one of those teachers who watched the clock, counting down minutes until they could leave. She was the opposite, the kind who stayed late on Friday afternoons because a student finally asked for help and she wasn't about to say no. Her classroom wasn't just a room with desks and a whiteboard. It was a space she deliberately built to feel welcoming. Student artwork covered the walls. Motivational quotes hung above the board. And her desk always had a bowl of candy that students knew they could grab from if they needed a little boost during a tough lesson. Colleen grew up in Andover, Massachusetts, just a few miles from Danvers. She was the third of 4 kids in a family that prioritized kindness above almost everything else. Her parents, Tom and Peggy Ritzer, raised their children in a home where dinner table conversations mattered and everyone checked in on each other. Colleen absorbed that culture completely. She wasn't kind because someone told her to be. She was kind because it was woven into who she was. Her siblings remembered her as the peacemaker growing up, the one who'd step in during arguments and find a way to make everyone laugh instead of fight. That quality followed her into adulthood, into her classroom, into every interaction she had with students who walked through her door carrying problems that had nothing to do with math but everything to do with feeling unseen. She'd wanted to be a teacher since elementary school, not in the vague way some kids say they want to be astronauts or firefighters. In the specific, committed way that meant she actually followed through. She went to Assumption College and graduated in 2011 with a degree in mathematics education. Got hired at Danvers High shortly after. By October 2013, she'd been teaching there for just over 2 years. And in that short time, she'd already become one of those teacher students remembered decades later. The kind who didn't just teach the curriculum. She taught students how to believe in themselves, how to keep trying when something felt impossible, how to ask for help without feeling stupid. She had this way of making every kid feel like they mattered, like their success was personal to her, because it was. Her classroom culture showed up in everything she did. She ran a Twitter account for her students where she posted daily encouragements and reminders. Messages like, no matter what happens in life, be good to people. Being good to people is a wonderful legacy to leave behind. She didn't post those things for attention. She posted them because she believed them. Her students knew it too. They'd talk about how Ms. Ritzer was different, how she actually cared if you passed, how she'd spend 30 minutes after school explaining one concept 5 different ways until it finally clicked, how she never made you feel dumb for not getting it the first time. One former student described it perfectly in a statement read during the trial. She said Colleen didn't just teach math. She taught students that someone believed in them. And for kids who didn't hear that anywhere else, that belief changed everything. October 22, 2013 started like any other Tuesday for Colleen. She taught her classes, smiled at students in the hallway, probably stopped to chat with colleagues in the teacher's lounge during her planning period. Danvers High was a good school in a safe town, the kind of place where teachers didn't think twice about staying late, where parents didn't worry when their teenagers said they'd be home after dark because they had tutoring. Colleen had stayed late hundreds of times before, sometimes for official after-school programs, sometimes just because a student caught her in the hallway and asked if she had a minute to explain something. She always had a minute. Always. That Tuesday was supposed to be the same. Stay a little late, help whoever needed help, lock up her classroom, drive home to Andover, call her mom like she did most evenings, make plans for the weekend, normal, unremarkable, safe. But Philip Chisum had decided it wouldn't be normal. He'd transferred to Danvers High just weeks earlier from Tennessee after his parents separated. New school, new state, no friends yet. Teachers described him as quiet but polite. He played soccer and showed some talent. Academically, he was fine. No behavioral red flags, no fights, No threatening comments. Nothing that would make anyone think twice about him. Colleen had him in her algebra class. She'd made an effort to welcome him like she did with all new students, asked how he was adjusting, encouraged him when he participated, treated him with the same warmth she showed everyone. She had no reason to be afraid of him. No reason to think that staying late on October 22nd would be any different than the 100 other times she'd stayed late before. The last confirmed sighting of Colleen alive was captured on the school's security camera system at 3:17 p.m. The footage shows her walking down a second-floor hallway toward the bathroom. She's carrying her phone and a folder. Her pace is normal, relaxed. There's nothing in her body language that suggests fear or concern. She's just a teacher finishing up her day, probably thinking about what she needed to do that evening or what she'd teach tomorrow. Behind her, about a minute later, the camera captures Philip Chisum. But he's not walking like a student heading home. He's wearing gloves, in October, inside a school building, and he's moving with purpose. And the camera angle doesn't show his face clearly, but it shows enough. He turns down the same hallway Colleen just walked down, toward the same bathroom, and then both of them disappear from the camera's view. What happened in that bathroom over the next hour would become the subject of forensic reports, autopsy findings, and trial testimony so disturbing that the judge cleared the courtroom of minors before allowing it to be presented. Colleen Ritzer fought for her life. The evidence made that clear, but she was 24 years old, barely over 5 feet tall, caught off guard by someone she had no reason to fear. Philip Chisum had brought a weapon, had worn gloves, had planned this. And when it was over, Colleen was gone. The teacher who stayed late to help students, who posted kind messages online. Oh, who believed in giving everyone a second chance, who'd done absolutely nothing to deserve what happened to her. She was 24 years old. She'd been teaching for 2 years, and she died in a school bathroom at the hands of a 14-year-old student she'd tried to welcome. The security camera system at Danvers High School wasn't designed to solve murders. It was basic institutional surveillance, fixed-angle cameras mounted at hallway intersections and building exits. The kind of setup meant to catch vandalism or document who left the building after hours. Low-resolution, grainy footage, timestamps cycling every few seconds instead of continuous recording. But on October 22, 2013, that unremarkable system became the most important witness in a murder investigation. Because while it couldn't see inside the bathroom where Colleen died, it saw everything before and after, and what it captured was so damning that defense attorneys would spend 2 years trying to explain it away and failing every single time. The timeline the cameras documented was methodical, precise. The kind of sequence that destroys any argument about impulsive teenage behavior. At 3:17 p.m., Colleen walks toward the second-floor bathroom. Normal pace. No indication anything is wrong. At 3:18 p.m., Philip appears in the same corridor. But he's not empty-handed anymore. He's wearing gloves. The footage was enhanced and blown up during trial. Entered as evidence. Shown to the jury. Those gloves weren't winter gloves he happened to be wearing. They were the kind you put on when you don't want to leave fingerprints, when you've thought ahead about evidence, when you've planned what you're about to do and taken steps to avoid getting caught. A 14-year-old doesn't accidentally put on gloves before following his teacher into a bathroom. That's not confusion. That's not a mental health crisis. That's preparation. For nearly an hour, nothing. The camera shows an empty hallway. Students have mostly left for the day. A custodian passes through at one point, pushing a cart, headphones in. Doesn't notice anything unusual. Why would he? It's a Tuesday afternoon in a safe school in a safe town. But inside that bathroom, something horrific is happening. Colleen is fighting for her life, struggling against a student she never saw coming. And when the fight ends, she's dead. The medical examiner would later testify about her injuries in clinical language that couldn't hide the brutality of what Philip Chisum had done. The courtroom went silent during that testimony. Some jurors looked away. But the facts were the facts. Colleen had been attacked with extreme violence by someone who didn't stop until she stopped moving. At 4:11 p.m., Philip reappears on camera. This time he's pushing a large yellow recycling bin, the kind schools use for paper and cardboard. He's moving deliberately, not running, not panicking, just pushing this bin down the hallway like he's doing a routine custodial task. The camera follows him as far as its angle allows. He heads toward the rear of the building, toward the doors that lead to the athletic fields and the woods beyond. And inside that recycling bin, our investigators would later discover, was evidence that would destroy any possibility of reasonable doubt. Colleen's belongings, her phone, items of her clothing, biological evidence that forensic analysts would match to both victim and killer, and blood. Enough blood that the bin itself became a key piece of evidence entered at trial with photographs that made more than one person in the gallery look away. Philip left the school through a rear exit at approximately 4:20 p.m. The camera at that door captured him leaving the building without the recycling bin. He ditched it somewhere between the hallway and the exit, walking out into the October afternoon like he'd just finished a normal school day. But he didn't go home. That's what made investigators certain this wasn't some emotional breakdown or psychotic episode. Philip Chisum walked to a nearby Wendy's restaurant, ordered food, sat in the dining area, and ate. Witnesses would later tell police they remembered seeing him, a teenager alone, calm, eating a burger and fries. Nothing unusual about his behavior, no visible distress, no signs that he'd just committed murder less than an hour earlier. After Wendy's, he went to a movie theater, bought a ticket, sat through a film, then walked out and started moving along Route 1 toward the neighboring town. Meanwhile, back at Danvers High, Colleen's absence was starting to register. She hadn't come home, hadn't answered her phone. Her family grew worried as evening turned to night. This wasn't like her. Colleen was responsible, reliable. She always checked in. Her parents called the school, called her friends. No one had seen her since the afternoon. By 8 p.m., they'd contacted Danvers police. Officers responded to the school and began what started as a welfare check but quickly escalated into something far more serious. They found Colleen's car still in the staff parking lot, found signs of a disturbance in the second-floor bathroom that made them immediately call for backup. And when they pulled the security footage and watched it, they knew exactly who they were looking for. The search for Colleen's body began that night. Officers fanned out across the school grounds with flashlights, calling her name, hoping against hope they'd find her alive somewhere. But at approximately 10:30 p.m., an officer searching the wooded area behind the athletic fields found what everyone had been dreading. Colleen's body was partially concealed under brush and leaves. She was still in her school clothes, still identifiable. The officer called it in immediately, and the scene was locked down. Forensic teams were called. The medical examiner was notified. And detectives who'd been reviewing the security footage now had confirmation of what that footage suggested. This was a homicide. Premeditated. Calculated. And they had a suspect's face clearly visible on camera. Now they just needed to find him. Philip Chisum was located just after midnight. A Topsfield police officer spotted a teenager walking along Route 1 several miles north of Danvers, alone, after midnight. The officer pulled over to check on him, asked his name, asked where he was going. Philip gave vague answers, and that's when the officer noticed the blood on Philip's clothing, on his hands, fresh enough that it hadn't fully dried. The officer called it in. Within minutes, Danvers detectives arrived. Philip was taken into custody without resistance. He didn't fight, didn't run, didn't ask for a lawyer right away. Just got into the police car and sat quietly while officers radioed ahead that they had him. The teenager who'd walked out of Danvers High 7 hours earlier pushing a recycling bin was now in handcuffs, and the mountain of evidence that would bury him at trial was just beginning to pile up. Philip Chisum didn't look like a killer. That's what people kept saying in the days after his arrest. Neighbors in Tennessee, where he'd lived before the move. Classmates at Danvers High who'd barely gotten to know him. Even some teachers who'd had him in class for just a few weeks. They all said the same thing. Quiet kid, polite, didn't cause trouble, played soccer. Seemed normal. But normal was exactly the problem. Because underneath that quiet exterior was something far more dangerous than anyone had noticed. And the warning signs, small as they were, had been there all along. People just didn't know what they were looking at until it was too late. Philip was born into a military family. His father served, which meant the family moved frequently. Tennessee, Georgia, brief stints in other states. That kind of childhood creates a specific type of kid. Someone who learns not to get too attached to places or people because everything is temporary. Someone who keeps emotional distance because forming deep connections doesn't make sense when you'll be gone in a year or two. For some military kids, that builds resilience. For others, it builds detachment. Philip fell into the second category. Teachers who'd had him in earlier grades described him as a student who was physically present but emotionally absent. He'd do the work, follow the rules. But there was never that spark of genuine engagement. Never that moment where you felt like you'd really reached him. His parents' marriage fell apart when Philip was 13. The separation was messy enough that his mother decided to relocate. Away from Tennessee. Away from the military community they'd been part of. She chose Massachusetts, Danvers specifically. A fresh start for both of them. Philip enrolled at Danvers High in September 2013. New state, new school, no history, no friends. Just a quiet 14-year-old trying to figure out where he fit. Or at least that's what it looked like on the surface. What people didn't realize was that Philip wasn't trying to fit in. And he was watching, observing, going through the motions of being a normal teenager while something else was happening in his head that nobody could see. His teachers at Danvers High noticed the same thing teachers in Tennessee had noticed. Philip was there, but not really there, present but disconnected. One teacher described it as talking to someone through glass. You could see them, you could hear them. But there was this barrier you couldn't get past. He'd answer questions when called on, complete assignments, show up to soccer practice. But he never volunteered information, never joined conversations in the hallway, never seemed to form real friendships with other students. A few classmates tried to include him, invited him to hang out after school. He'd decline politely, always had an excuse. After a while, people stopped asking. He became part of the background, the quiet new kid who kept to himself. But quiet doesn't mean harmless, and keeping to yourself doesn't mean you're just shy. Philip's internal world was nothing like what people assumed from watching him move through the school day. The psychiatric evaluations conducted after his arrest revealed a psychological profile that explained a lot, but excused nothing. He scored high on measures of callous unemotional traits. That's the clinical term for what most people would call a lack of empathy. The inability to feel genuine remorse, the absence of emotional connection to other people's pain. It's not the same as being shy or socially awkward. It's a fundamental difference in how someone processes human emotion, and it's one of the strongest predictors of violent behavior in adolescence. He's stronger than poverty, stronger than abuse, stronger than almost any other risk factor researchers have identified. The defense would later argue that Philip's psychological profile was the result of trauma. The family instability, the constant moving, the parental separation, and maybe those things contributed. But trauma doesn't usually create callous unemotional traits. It creates anxiety, depression, emotional dysregulation. What Philip showed was something different, something that looks less like a reaction to pain and more like an absence of the capacity to feel pain in the first place. At least not the kind of pain that comes from hurting someone else. He could feel anger, frustration, wounded pride. But guilt, remorse, empathy for Colleen Ritzer's family? The evidence suggested those emotions simply weren't accessible to him, not because he was suppressing them, but because they weren't there to suppress. Looking back at the weeks before October 22nd, a few moments stood out to investigators. Small things that hadn't seemed significant at the time, but took on new meaning after the murder. Philip had been quiet in Colleen's class, but he'd also been watching her. Other students noticed he'd stare sometimes, not in an obvious way, just longer than normal. One classmate mentioned it to investigators, said it had felt a little weird, but not threatening. Just strange. Another student remembered Philip asking questions about Colleen's schedule, when she stayed late, which days she had tutoring. At the time, it seemed like a new student trying to figure out when he could get extra help. In hindsight, it looked like something else entirely. Like someone gathering information, planning. The digital forensics team recovered Philip's search history from his phone and laptop. What they found supported the prosecution's theory that this wasn't an impulsive act. In the days before the murder, Philip had searched for information about anatomy, about violence, about how security cameras work. The specific searches weren't released to the public, but prosecutors described them in court as evidence of premeditation, evidence that Philip had been thinking about this, planning it. The defense argued those searches could mean anything: teenage curiosity, research for a school project. But combined with everything else, the pattern was clear. Philip Chisum hadn't snapped on October 22nd. He'd decided, prepared. And when the opportunity came, he executed exactly what he'd been thinking about for days or maybe weeks. The investigation moved fast once Philip Chisum was in custody. Danvers police had the security footage. They had the body. They had a suspect with blood on his clothes, walking alone after midnight. But prosecutors knew that getting a conviction against a 14-year-old defendant would require more than just strong evidence. It would require perfect evidence, the kind that left no room for doubt, no gaps for the defense to exploit, no procedural mistakes that could get key findings thrown out on appeal. So they built their case like they were preparing for war. Every piece of evidence documented, every chain of custody verified, every forensic test conducted by certified experts who could withstand cross-examination. And what they assembled over the following weeks was devastating. The recycling bin was found in the woods near where Colleen's body was discovered, still partially full of contents that told the story of what Philip had tried to hide. Forensic analysts processed every item inside. Colleen's belongings were there: her phone, pieces of her clothing, and biological evidence that DNA analysis conclusively matched to both Colleen and Philip. The defense would later try to challenge the DNA results, brought in their own expert to question the lab's methodology. But the findings held up. The science was solid. Philip Chisum's genetic material was inside that bin, mixed with evidence of the crime. There was no innocent explanation for that, no way to argue contamination or coincidence. The bin connected Philip directly to what happened in that bathroom and to the disposal of evidence afterward. The box cutter was recovered during a search of the wooded area the morning after Colleen's body was found. It had been discarded in the brush about 50 yards from where Philip had left the recycling bin. The weapon was processed for fingerprints and touched DNA. Both came back positive for Philip Chisum. The defense would argue that the box cutter could have been handled innocently, that Philip might have picked it up somewhere, used it for a legitimate purpose. But the location where it was found destroyed that argument. You don't accidentally drop a box cutter in the woods behind a high school on the same night your teacher is murdered in that school unless you're trying to get rid of evidence. And the prosecution didn't need to prove Philip confessed. They just needed to prove the physical evidence told a story. And that story had exactly one logical conclusion. Philip's clothing from the night of his arrest was seized and sent to the state crime lab. The blood on his shirt and pants was tested, came back as a match for Colleen Ritzer. His shoes, which investigators noted were different from the ones visible in the earlier security footage, were never recovered. Philip had ditched them somewhere between leaving the school and getting picked up by police. That alone suggested consciousness of guilt. Innocent people don't change shoes and throw away the original pair. People trying to hide evidence do. The prosecution added it to the growing list of behaviors that demonstrated premeditation and deliberate concealment. Every action Philip took after the murder pointed toward someone who knew exactly what he'd done and was actively trying to avoid getting caught. The digital evidence added another layer. Philip's phone records showed his location throughout the evening of October 22nd. The phone's GPS data placed him at Danvers High during the time of the murder, then at Wendy's, then at the movie theater, then moving north along Route 1. The timeline matched witness statements perfectly. Employees at Wendy's confirmed seeing a teenager matching Philip's description. Calm, eating alone. Nothing unusual about his behavior. The movie theater had surveillance footage showing Philip buying a ticket and entering the theater around 6 p.m. He'd sat through most of the film before leaving and starting his walk north. The defense would argue this proved Philip was experiencing some kind of dissociative state, that he wasn't in his right mind, but prosecutors saw it differently. They saw a killer buying himself time, creating distance between himself and the crime scene. Acting normal so no one would remember him as suspicious. Text messages recovered from Philip's phone became a critical piece of evidence that the prosecution referenced but didn't fully disclose to the public. The content was described in court as communications that reflected cognitive patterns consistent with someone planning violence. The judge allowed the messages to be shown to the jury under seal. Whatever those messages contained, they were significant enough that multiple jurors visibly reacted when they were displayed. The defense objected to their inclusion. I'd argued they were being taken out of context, but the objection was overruled. The jury saw them. And the jury's verdict suggested those messages did exactly what the prosecution intended. They proved this wasn't a sudden snap. It was a buildup. Witness interviews filled in the rest. Students who'd been in Colleen's class with Philip were questioned. Most didn't have much to offer. Philip had been quiet, kept to himself, but a few remembered small details that mattered. The staring, the questions about Colleen's schedule. One student recalled Philip seeming irritated during a class discussion in the days before the murder. Colleen had been talking about respect and kindness. Philip had made a comment under his breath. The student sitting next to him heard it but couldn't remember exactly what was said, just that it felt off. Another student mentioned seeing Philip in the hallway after school on October 22nd. Thought it was weird he was still there so late. Didn't think much of it at the time. All these little observations became puzzle pieces. Individually, they didn't prove anything. Together, they painted a picture of someone who'd been fixated on Colleen Ritzer and waiting for an opportunity. The forensic timeline established by the medical examiner was precise. Colleen died between 3:30 and 4 p.m. based on body temperature and lividity patterns. The injuries she sustained were consistent with a sustained attack. She'd fought back. Defensive wounds on her hands and arms proved that. But she'd been overpowered. The medical examiner's testimony would later describe the sequence of the attack in detail that left the courtroom shaken. It wasn't quick. It wasn't merciful. Philip Chisum had time to stop. Multiple opportunities to realize what he was doing and walk away. He didn't. He kept going until Colleen stopped moving. And then he spent the next hour cleaning up, moving her body, disposing of evidence. All of that took time. Planning. The kind of deliberate action that would become the prosecution's most powerful argument against treating Philip like a confused child who'd made a terrible mistake. The trial began on November 14th, 2015, more than 2 years after Colleen Ritzer's murder. The delay wasn't unusual for a case this serious. Pretrial motions had consumed months, competency evaluations, psychiatric assessments, arguments over whether Philip should be tried as an adult or a juvenile. The prosecution won that fight. Philip Chisum would face adult charges in adult court. His attorneys appealed, lost, and now here they were. Essex Superior Court in Salem, Massachusetts, a courthouse that carried the weight of centuries. The same building where witch trial documents were still preserved in archives downstairs. History lived in these walls, and history was about to be made again. The gallery filled early every single day. Colleen's family occupied the front rows behind the prosecution table. Tom Ritzer sat with his shoulders squared, Peggy beside him. Their other children came when they could. The pain on their faces was visible to everyone, but so was their determination. They weren't going to let Philip Chisum's lawyers rewrite what happened to their daughter. Weren't going to let psychology reports and brain scans turn a calculated murder into a medical condition. They'd been told the trial would be difficult, that they'd hear things no parent should ever hear about their child. They came anyway, every single day, because Colleen deserved witnesses, deserved people who'd sit through the worst of it and make sure the truth got told. Philip Chisum sat at the defense table in clothes his attorneys had carefully selected. Button-down shirts, neutral colors, nothing flashy, nothing that made him look dangerous. The goal was obvious. Make the jury see a kid, a confused, troubled, mentally unwell kid who needed help, not punishment. His legal team was experienced. They knew what they were doing, but they also knew they were facing an uphill battle. The evidence wasn't just strong, it was overwhelming. So their strategy focused on the one thing they could argue: Philip's age, his brain development, on the idea that 14-year-olds can't fully understand consequences the way adults do. It was a legally sound argument, backed by neuroscience, supported by Supreme Court precedent. It just had one problem. It required the jury to ignore what the evidence showed about who Philip actually was. The prosecution's opening statement laid out the case with methodical precision. The assistant district attorney stood before the jury and walked them through the timeline. October 22, 2013. A teacher stays late to help students. A 14-year-old puts on gloves, brings a weapon, follows her into a bathroom. The surveillance footage would show them exactly what happened, before and after. The forensic evidence would show them what happened during. And the defendant's own behavior after the murder would show them this wasn't a confused child having a breakdown. This was someone who knew exactly what he'd done and spent the next 7 hours trying to get away with it. She didn't raise her voice. Didn't need to. The facts spoke loudly enough on their own. The defense's opening painted a completely different picture. Philip Chisum was a traumatized child, displaced from everything familiar, processing his parents' divorce, struggling with mental health issues nobody had identified or treated. What happened on October 22nd was a tragedy, but it was the tragedy of a broken child having a psychological crisis, not a calculated predator executing a plan. The attorney's voice carried genuine emotion. He wasn't lying. He believed what he was saying. Believed that 14-year-olds deserve different treatment than adults. That brain science matters. That rehabilitation is possible. The argument would have been compelling in a different case. A case with different evidence. But this case had gloves, and box cutters, and recycling bins, and a teenager eating fast food an hour after murdering his teacher. The jury listened to both sides. 12 people who'd been selected after extensive questioning. People with no connection to Danvers, no pre-existing opinions about the case. They'd promised to keep an open mind, to weigh the evidence fairly. And now they sat in those jury box seats, knowing they'd be there for weeks, knowing they'd see things they couldn't unsee, hear things they couldn't unhear. The judge had warned them during selection. This case involved graphic evidence, a disturbing testimony. If anyone couldn't handle that, now was the time to say so. Nobody did. They'd committed, and now the prosecution would begin calling witnesses to build the case that would haunt some of those jurors for the rest of their lives. The first witnesses were procedural. Police officers who responded to the scene. The officer who found Colleen's body. His voice stayed steady while he described it, but you could see the weight in his expression. 20-plus years on the force, and this was the one that stuck with him. The defense didn't cross-examine aggressively. Couldn't. These weren't opinions. These were observations. Facts. The body was where he said it was, in the condition he described. Moving on, the court reporter's fingers flew across her machine, every word documented, at every detail entered into the permanent record. Outside the courthouse, news crews set up cameras. This was a story that had gripped Massachusetts for 2 years. Now people would finally hear what really happened. The prosecution called a Danvers High administrator to authenticate the security footage. Walked through the system, how it worked, where cameras were positioned, what timestamps meant. Then they played the video. The courtroom went completely silent. You could hear people breathing. Nothing else. Colleen walking down the hallway, Philip following in gloves. The time gap, Philip emerging with the recycling bin. The jury watched without moving. Some leaned forward. Some sat very still. But all of them were absorbing what they were seeing. This wasn't a story anymore. This wasn't competing narratives from lawyers. On this was Philip Chisum on camera doing exactly what the prosecution said he did. And when the video ended, the prosecutor didn't add commentary. Just said quietly, "That's what deliberate looks like." The defense objected. Too late. The jury had already heard it, already seen it, and nothing the defense said from that point forward could erase what those cameras had captured. The forensic evidence phase of the trial was where the prosecution turned a strong case into an unbeatable one. They'd already shown the jury the surveillance footage, already established timeline and opportunity. Now they needed to prove beyond any shadow of doubt that Philip Chisum had murdered Colleen Ritzer and done so with premeditation. That meant bringing in the scientists, the DNA analysts, the medical examiner. The people who'd spent months processing evidence and could explain in precise technical language exactly what that evidence meant. The defense knew this phase would be brutal. They'd filed motions to exclude some of it. Lost most of those fights. Now they'd have to sit there and watch the prosecution bury their client under a mountain of scientific proof. The DNA analyst took the stand first. She was a veteran of the state crime lab, had testified in dozens of trials, knew how to explain complex science in language regular people could understand. She walked the jury through the evidence recovered from the recycling bin, explained how DNA analysis works, how they extract genetic material, how they compare it to known samples, how they calculate the probability of a match. Then she delivered the findings. The biological evidence in that bin matched Colleen Ritzer. And it matched Philip Chisum. The probability of it being anyone else was so astronomically low that it was functionally impossible. She showed charts, graphs, data that the defense's own expert would later review and be unable to contradict. The science was solid. Philip Chisum's DNA was mixed with evidence of the crime in a container he'd been captured on camera pushing out of the school. The box cutter evidence came next. A different analyst specialized in fingerprint and touch DNA analysis. He explained how touch DNA works, how skin cells transfer when someone handles an object, how those cells can be collected and analyzed even when visible fingerprints aren't present. The box cutter recovered from the woods had both. Partial fingerprints that matched Philip Chisum's known prints from his arrest, and touch DNA that confirmed he'd handled the weapon. The defense tried to create doubt during cross-examination, asked if the box cutter could have been handled at a different time, for a different purpose. The analyst answered calmly, "Possible, but unlikely." The box cutter was found 50 yards from a murder victim in the woods behind a school. Context matters. The jury got the message. You don't accidentally leave a box cutter in those woods unless you're disposing of a murder weapon. Then came the testimony everyone had been dreading. The medical examiner, Dr. Michelle Jordan, had conducted Colleen Ritzer's autopsy, had documented every injury, every wound, every detail of what had been done to her in that bathroom. Before she began testifying, the judge addressed the gallery. This testimony would be graphic. Anyone who couldn't handle it should leave now. A few people stood and walked out. Colleen's family stayed. They'd been warned. They'd prepared as much as anyone could. Dr. Jordan's voice stayed clinical throughout. Professional. She described injuries using anatomical terms, showed diagrams, explained cause of death. But no amount of clinical language could hide the reality. Colleen had been attacked with extreme violence, had fought for her life, had sustained injuries that proved this wasn't quick or painless. The jury sat frozen. Several looked visibly shaken. One juror wiped tears away. The defense didn't object to any of it. Couldn't. This was the truth of what their client had done. Dr. Jordan's testimony established something critical for the prosecution. Time. The nature and number of Colleen's injuries meant this attack lasted several minutes. Philip had time to think, time to stop, time to realize what he was doing and walk away. He didn't. That timeline destroyed any argument about a momentary loss of control, about a split-second decision made by an underdeveloped teenage brain. This was sustained violence, deliberate, continued past the point where Colleen stopped fighting back. The medical examiner's findings matched everything else: the gloves, the weapon, the cleanup afterward. This was planned, executed, and the person who did it showed no mercy even when his victim was helpless. The prosecution played Colleen's final Twitter post next, projected it on a screen for the jury. No matter what happens in life, be good to people. And being good to people is a wonderful legacy to leave behind. Posted the morning of October 22nd, hours before Philip Chisum murdered her. The prosecutor didn't comment on it, didn't need to. The contrast spoke for itself. A teacher encouraging kindness, a student planning violence. The post stayed on the screen for several seconds, long enough for everyone to read it, long enough for the meaning to sink in. Then it disappeared, and the prosecution moved to their next witness. But the damage was done. The jury had just seen who Colleen Ritzer was, what she believed, what she'd tried to teach, and they'd already seen what Philip Chisum had done in response. Student witnesses testified next. Kids who'd been in Colleen's class with Philip. Most didn't have dramatic revelations, just small observations. Philip had been quiet. He had stared at Colleen sometimes, had asked about her schedule. One student described an incident about a week before the murder. Philip had seemed angry during class. Colleen had been talking about treating people with respect. Philip had muttered something under his breath. The student didn't hear exactly what, just remembered thinking it was weird. The defense tried to downplay it during cross. Teenage muttering doesn't prove murder. But combined with everything else, it fit the pattern. Philip hadn't suddenly snapped on October 22nd. He'd been building toward something, thinking about something, and these small moments were glimpses of what was happening in his head. The digital forensics specialist testified about Philip's phone, the GPS data, the location tracking. Everything confirmed what the surveillance footage had shown. Philip was at the school during the murder, then at Wendy's, then at the movie theater. The specialist also addressed the search history. The judge had ruled that certain searches could be described but not shown in detail to the gallery or press. The jury saw them under seal. Their reactions told the story. Eyes widening, expressions hardening. Whatever Philip had been searching for in the days before the murder, it wasn't homework. The defense objected repeatedly. argued the searches were taken out of context, but the judge overruled them every time. The evidence was relevant. The jury needed to see it. When the prosecution rested after 2 weeks of testimony, they'd built something almost unheard of in criminal trials, a case with no weak points, no gaps, no reasonable alternative explanation. And the surveillance footage showed Philip following Colleen with gloves and leaving with the recycling bin. The DNA evidence put him in that bin with evidence of the crime. The box cutter connected him to the weapon. The medical examiner proved the violence. The digital evidence proved the planning. And Philip's own behavior afterward proved consciousness of guilt. The defense had spent months preparing for this trial, had retained experts, built arguments. But now they were facing a mountain of evidence that all pointed in one direction, and they still had to put on their case, knowing the jury had already seen enough to convict 10 times over. The victim impact statement phase came after the guilty verdict. Philip Chisum had been convicted on all counts: first-degree murder, aggravated rape, armed robbery. The jury had deliberated less than a full day. The evidence had been too overwhelming, too clear. Now came the part of the process that belonged entirely to Colleen's family, the part where the court stopped talking about evidence and exhibits and started talking about a real person, a daughter, a sister, a teacher whose absence left a hole that could never be filled. The Ritzer family had been waiting 2 years for this moment, 2 years of court dates and continuances and legal arguments. Now they'd finally get to speak directly about what Philip Chisum had taken from them. Tom Ritzer stood first, walked to the podium with a piece of paper clutched in his hand. His voice shook from the first word. He talked about Colleen as a little girl, how she'd announced at 8 years old that she wanted to be a teacher, how she'd lined up her stuffed animals and taught them math, how that dream never wavered, not through middle school, not through high school, not through college. She'd wanted to teach, and she'd done it, had become exactly who she'd dreamed of being. And then, at 24 years old, with her whole life ahead of her, she'd been murdered by a student she'd tried to welcome. Tom's voice broke multiple times. He paused to collect himself, looked down at his notes, and then back up. The courtroom waited. Nobody rushed him. This was his time. He talked about the empty chair at their dinner table, how Peggy still set a place for Colleen sometimes, not because she forgot, but because some habits of love are too deep to break. He talked about holidays without her, birthdays that would never be celebrated, the future she'd never get to live. Colleen had wanted to get married someday, have kids, be the kind of teacher who stayed in touch with former students for decades. All of that was gone, erased by a 14-year-old with a box cutter and no conscience. Tom looked directly at Philip Chisum while he spoke. Philip sat at the defense table expressionless, didn't look away, didn't look down, just stared back with that same flat affect he'd maintained through the entire trial. Tom's voice got quieter toward the end. He wasn't asking for anything, wasn't begging for a specific sentence, just wanted Philip to know, wanted everyone to know. Colleen had mattered. Her life had value, and that value didn't disappear just because someone took it away. Peggy Ritzer stood next. She was smaller than her husband, her voice softer, but the weight of what she carried was just as heavy. She talked about the morning of October 22nd, 2013, how Colleen had left for school like always, kissed her mother goodbye, said she'd call later. That was the last conversation they ever had, the last time Peggy heard her daughter's voice. She talked about the phone call that evening, the police asking if Colleen had come home, the growing panic as hours passed and nobody could find her, the moment officers came to the house and she knew from their faces that Colleen was gone. That moment broke something in Peggy that would never be fixed. You could hear it in her voice, see it in the way she held herself together through sheer force of will. Peggy did something then that took enormous courage. She turned away from the podium and looked directly at Philip Chisum, addressed him by name, asked him if he understood what he'd done. Oh, if he grasped that Colleen wasn't just a name in court documents, but a real person with a real family who loved her. She asked if he'd thought about her parents when he was planning this, if he'd considered for even 1 second what it would do to them. Her voice didn't rise, she wasn't yelling, but the questions carried weight that silence never could. The courtroom held its breath. Philip Chisum sat motionless, and then it happened. The thing that would seal his fate more than any piece of evidence. The corner of his mouth moved, just slightly, but unmistakably. That same smirk he'd worn during trial, right there while a grieving mother begged him to show a shred of humanity. The gallery saw it instantly. The reaction rippled through the room like electricity. Colleen's siblings saw it, the prosecutor saw it, and one of them made a note. Journalists saw it, and later their articles would describe that exact moment. Court officers saw it, and Judge David Loey saw it. He'd been watching Philip carefully throughout the impact statements, probably wondering if any genuine remorse would surface now that the trial was over, now that there was no tactical reason to hide emotion. But the smirk answered that question definitively. Philip Chisum felt nothing, not guilt, not shame, not empathy for the family he'd destroyed, just contempt, visible, undeniable contempt. And the judge's expression changed, hardened. Something shifted in his eyes that told everyone watching that whatever small mercy might have been possible was gone now. Peggy finished her statement and sat down. Her family wrapped arms around her. Other family members spoke. Colleen's siblings are each one talking about what their sister had meant to them, the memories they'd never get to make, the nieces and nephews Colleen would never meet. Former students sent written statements that were read aloud. One described Colleen as the first teacher who'd ever made her feel smart. Another talked about failing algebra until Colleen's tutoring sessions turned everything around. A third said simply that Ms. Ritzer had saved her life. Not dramatically, just by being kind when nobody else was, by noticing when she was struggling, by caring enough to ask if she was okay. Those small acts of teaching had meant everything, and Philip Chisum had ended them. The statements went on for over an hour. By the end, there wasn't a dry eye in the gallery except for one person. Philip Chisum sat unmoved, and his attorneys had whispered to him urgently after the smirk, probably told him to control his expression, show some emotion, anything. He'd complied by going back to flat neutrality. But it was too late. The judge had seen what he needed to see. The prosecution had seen it. And most importantly, the record would reflect it, because judges don't usually cite specific courtroom demeanor in their sentencing remarks. But Judge Loey would. He'd reference that smirk directly. Use it as evidence of exactly the kind of callous indifference the psychiatric reports had documented. Philip Chisum had been given a chance to show he was something other than what the evidence suggested. He'd chosen instead to confirm it. When the last statement was read, the judge called for a brief recess before sentencing. The Ritzer family stayed seated. They'd made it through the hardest part, putting their grief into words in front of the person who'd caused it. They'd done what they came to do, made sure the court understood that Colleen wasn't just a victim in a case file. She was their daughter, their sister, their teacher, a real person with a real life that had been stolen. Now it was the judge's turn, the moment everyone had been waiting for, the moment that would determine what Philip Chisum's age and his smirk and his complete lack of remorse would actually cost him. The gallery settled into tense silence. The court officers took their positions, and Judge David Loey prepared to make history. The defense knew they were fighting uphill. The guilty verdict was in. The evidence had been overwhelming. Philip Chisum's own behavior during victim impact statements had damaged him in ways no legal argument could fix. But they still had one card left to play: sentencing. And in Massachusetts, sentencing a juvenile offender for murder required the court to consider factors that gave the defense real legal ground to stand on. Brain science. Supreme Court precedent. The fundamental principle that children are different from adults in ways that matter under the law. Philip Chisum's attorneys had built their entire strategy around that principle. Now they'd present it, knowing that the judge had just watched their client smirk at a grieving mother. But the law was the law, and they'd make their argument. The neuroscience argument was first. The defense called Dr. Richard Dudley, a forensic psychologist who specialized in adolescent brain development. He'd evaluated Philip extensively, conducted interviews, reviewed his history, administered psychological tests. His testimony walked the jury through what's become widely accepted science. The adolescent brain isn't fully developed, particularly the prefrontal cortex, the region responsible for impulse control, long-term planning, and understanding consequences. That development doesn't complete until the mid-20s. At 14, Philip's brain was fundamentally different from an adult brain, less able to regulate emotion, more susceptible to impulsive behavior, less capable of fully grasping the permanence of death. Dr. Dudley's testimony was credible, well-researched, and the kind of expert witness who'd testified in dozens of cases and helped shape juvenile sentencing law. But the prosecution was ready. During cross-examination, the assistant district attorney asked Dr. Dudley about the gloves, about premeditation, about the specific behaviors Philip exhibited before, during, and after the murder. She asked whether adolescent brain development explained wearing gloves to avoid fingerprints, whether impulsivity explained bringing a weapon to school, whether poor long-term planning explained disposing of evidence and attempting to flee. Dr. Dudley tried to maintain his framework, said that adolescents can plan in the short term even if they don't fully understand long-term consequences. But the prosecutor pressed, asked him to explain the box cutter, the recycling bin, the stop at Wendy's for food, the movie theater, walking along Route 1 at midnight. Which of those behaviors suggested impulsivity? Which suggested a brain that couldn't understand consequences? Dr. Dudley's answers got more qualified, more hesitant. The science was real, but applying it to this specific case was harder than the defense needed it to be. The defense presented Supreme Court precedent next. Their legal argument focused on three major cases: Roper versus Simmons, which abolished the death penalty for juveniles; Graham versus Florida, which banned life without parole for non-homicide juvenile offenses; and most importantly, Miller versus Alabama, which ruled that mandatory life without parole for juvenile murderers was unconstitutional. Miller required courts to consider youth as a mitigating factor, to look at the individual circumstances, to account for the possibility of rehabilitation. The defense argued that Philip deserved a sentence that reflected those principles, a sentence that gave him a realistic chance at parole, at demonstrating growth and change, at eventually re-entering society as someone who'd learned from this tragedy and become better. It was a legally sound argument. Miller versus Alabama was binding precedent. The court was required to consider Philip's age. But the prosecution's response was equally sound. They didn't dispute Miller. They argued that Miller required individualized consideration, not automatic leniency, that the court needed to look at this specific juvenile offender and assess whether the qualities that make youth generally mitigating applied here. And they argued that in Philip Chisum's case, they didn't. The brain science was real, but it didn't explain premeditated violence. The possibility of rehabilitation was real, but it required some evidence of remorse, of insight, of capacity for change. Philip had shown none of those things, not during the investigation, not during the trial, not during victim impact statements when he'd smirked at Colleen's mother. The prosecution asked the court to do exactly what Miller required: look at the individual and sentence him accordingly. Philip's mother testified during the sentencing phase. It was the most emotionally difficult moment of the defense's presentation. She talked about her son before the crime, the quiet boy who'd played soccer, who'd said please and thank you, who'd called her from school sometimes just to check in. She talked about the family separation, the move to Massachusetts, how hard it had been on Philip to leave everything familiar behind. She wasn't making excuses, wasn't saying the separation justified murder, just trying to give context, trying to show the court that Philip had been struggling in ways she hadn't fully understood, that if she'd known, if anyone had known, maybe they could have gotten him help before October 22nd happened. Her voice broke multiple times. She was a mother trying to save her son, knowing what her son had done, navigating that impossible space where love and horror coexist. The prosecution didn't cross-examine her aggressively. They didn't need to. Her testimony was heartbreaking, but it didn't change the facts. Philip's difficult home life didn't explain the gloves, didn't explain the weapon, didn't explain the smirk. Thousands of teenagers experience parental separation every year. They don't murder their teachers. The defense knew that, but they had to present something human, something that reminded the court Philip was someone's child, someone who'd been loved, someone who might still be capable of becoming better than what he'd shown so far. It was their job to advocate for him, to find every possible argument for mercy. They'd done that. Whether it would be enough was now entirely up to the judge. The defense's closing argument pulled everything together. Philip Chisum was 14 when this happened. His brain wasn't fully developed. His home life was unstable. His mental health issues had gone undiagnosed and untreated. What happened to Colleen Ritzer was a tragedy, an absolute tragedy. But responding to it by locking Philip away forever wouldn't bring her back, wouldn't serve justice, wouldn't honor the principles the Supreme Court had established about treating juveniles differently. The defense asked for a sentence with a realistic parole date, something that gave Philip a chance to grow, to get treatment, to eventually demonstrate that he'd become someone different than the 14-year-old who committed this crime. It was an emotional closing, professionally delivered, and it rested on a foundation of real legal principles that courts across the country had recognized. But when the defense attorney sat down, everyone in that courtroom knew the same thing. Legal principles matter. But so does evidence. So does behavior. So does that smirk. Judge David Loey had been taking notes throughout the sentencing hearing. Num had listened carefully to every argument, every expert, every plea. Now he'd go back to his chambers and decide what Philip Chisum's youth meant in the context of everything else, what the science meant against the backdrop of gloves and box cutters, what the possibility of rehabilitation meant when measured against 2 years of complete absence of remorse. The courtroom emptied slowly. People spoke in hushed voices. And somewhere in his chambers, Judge David Loey began writing the statement that would change juvenile sentencing law in Massachusetts. The morning of February 26, 2016, felt different from every other court date. There was a finality to it, an electricity in the air that comes when everyone knows something significant is about to happen. The gallery filled earlier than usual. At people who'd followed the case from the beginning wanted seats. Colleen's family arrived together. Tom and Peggy Ritzer walked in holding hands, their other children beside them. They'd been through 2 years of legal proceedings, 2 years of reliving the worst day of their lives over and over. Today it would end. Not the grief. That would never end. But the legal chapter, the courtroom's answer to what Philip Chisum's life was worth, measured against what he'd taken. They sat in their usual spot, front row, directly behind the prosecution. Ready. Philip Chisum was brought in from holding. He was 17 now, taller than he'd been at 14. His face had lost some of that boyish softness, but the expression was the same, that flat, controlled neutrality that had defined every court appearance. His attorneys sat on either side of him, and they'd done everything they could, made every argument, called every expert, filed every motion. Now it was out of their hands. The sentence would come from Judge David Loey. A man who'd presided over this case with careful attention to every detail, who'd ruled on dozens of motions, who'd watched Philip Chisum sit through a trial without showing emotion and then smirk during victim impact statements. The defense team knew their client had hurt himself badly with that smirk, but they'd still present their best case for mercy. Still ask the judge to see a child who deserved a second chance. Judge Loey entered, and everyone stood. He took his seat at the bench, and the courtroom settled. He didn't begin immediately. Took a moment to arrange the papers in front of him, notes he'd prepared over the past several days. This wasn't going to be a quick sentencing, not the standard procedure where a judge announces a number and moves to the next case. This was going to be a statement, the kind of ruling that gets cited in law schools, that defense attorneys and prosecutors study for years afterward. Judge Loey had clearly spent significant time crafting his remarks, making sure every word would hold up under appellate review, making sure his reasoning was clear, documented, and legally sound. He started by acknowledging the difficulty of the case, stated clearly that sentencing a juvenile offender for murder is one of the most serious responsibilities a judge faces, that the law requires careful consideration of factors that don't apply in adult cases, that he'd reviewed the Supreme Court precedents, the neuroscience research, the psychological evaluations, the defense's arguments. He'd given all of it serious weight. He wasn't dismissing any of it. This wasn't a judge rushing to harsh judgment. This was a judge demonstrating that he'd done exactly what Miller versus Alabama required. He'd looked at the individual circumstances, considered Philip's age and background, assessed the possibility of rehabilitation. Now he was going to explain what that individualized consideration had led him to conclude. Judge Loey talked about the evidence, not all of it, just the pieces that mattered most for sentencing. The gloves, the premeditation they represented, the box cutter, the deliberate decision to bring a weapon, the surveillance footage showing Philip moving through the school with purpose, the disposal of evidence afterward, the stop at Wendy's, the movie theater, by the calm, calculated behavior that continued for hours after Colleen's murder. The judge's voice stayed even, professional. But the weight of what he was describing filled the courtroom. This wasn't a confused teenager having a breakdown. This wasn't impulsive violence driven by an underdeveloped brain. This was planned, executed, concealed, and the law required him to account for that. Then Judge Loey did something that made the entire gallery lean forward. He addressed Philip's courtroom behavior directly, talked about watching him throughout the trial, noted his flat effect, his lack of visible emotion. And then he referenced the smirk. Said explicitly that during victim impact statements, while Colleen Ritzer's mother was speaking, the defendant displayed an expression that could only be interpreted as contempt. The judge didn't speculate about what Philip was feeling, didn't try to read his mind, just stated what everyone in the courtroom had witnessed. That expression was part of the record now, part of the totality of evidence the court was required to consider when assessing remorse, insight, and capacity for rehabilitation. The defense attorneys shifted in their seats. They'd known this was coming, but hearing it stated so directly from the bench was damaging. Judges rarely cite specific demeanor moments in sentencing remarks. It's considered subjective, hard to defend on appeal. But Judge Loey wasn't being subjective. He was being observational. Multiple people had witnessed the smirk. It happened in open court. It was as much a part of the record as any exhibit or testimony. And what it demonstrated, combined with everything else, was exactly what the prosecution's psychological experts had described: callous, unemotional traits, a lack of empathy, the kind of profile that suggested poor response to conventional rehabilitation. Judge Loey addressed the defense's arguments next, acknowledged the neuroscience, said the research on adolescent brain development is valid and important, that courts must take it seriously, but he also said that science describes general patterns, not individual cases, that while the average 14-year-old has an underdeveloped prefrontal cortex, not every 14-year-old who commits violence does so because of impulsivity or poor judgment. Some do so because of other psychological factors that brain development research doesn't fully explain. Philip Chisum's behavior before, during, and after the murder suggested he fell into that second category. The planning suggested intact executive function. The concealment suggested awareness of consequences. The courtroom behavior suggested something deeper than developmental immaturity. The courtroom was completely silent. Nobody moved. Nobody whispered. The only sound was Judge Loey's voice and the court reporter's fingers on her machine. Colleen's family sat motionless. They'd waited so long for this, wondered if the justice system would really hold Philip accountable, or if his age would become a shield that made the sentence feel meaningless. Now they were hearing a judge engage seriously with both the law and the evidence. Explain why this case was different. Why Philip Chisum's youth, while legally relevant, didn't override what the totality of his behavior demonstrated. So it was the judicial reasoning they'd hoped for, but hadn't been sure they'd get. Judge Loey paused, looked directly at Philip Chisum. The courtroom held its breath. This was it. The moment before the sentence. The last few seconds before history was made. Philip met the judge's gaze with the same expression he'd worn throughout. No fear, no remorse, just that flat, controlled neutrality that had defined him from the beginning. And in that moment, looking at the teenager who'd murdered a beloved teacher and shown no sign of caring, Judge David Loey prepared to deliver the sentence that would rewrite the conversation about juvenile justice in Massachusetts and far beyond. Judge David Loey sentenced Philip Chisum to life in prison with the possibility of parole after 40 years. The words landed in the courtroom like a gavel strike. Life? At 40 years. Philip would be in his mid-50s before he could even be considered for release. It wasn't life without parole, which the Supreme Court had restricted for juvenile offenders. But it was close enough that the message was unmistakable. This court was not treating Philip Chisum's age as a get-out-of-jail card, was not letting brain science override the brutal reality of what he'd done and how he'd behaved afterward. The sentence for the rape conviction came next. Consecutive, not concurrent. More years added. Then the armed robbery conviction. More time. The total sentencing structure meant that even with perfect behavior, Philip wouldn't see freedom until he was well into his 50s. And that was only if a parole board decided he'd earned it. But the number wasn't what made history. Our judges sentenced juvenile killers to decades in prison regularly. What made this sentencing historic was the statement that accompanied it. Judge Loey spent nearly 30 minutes explaining his reasoning in detail that went far beyond what most sentencing remarks contain. He addressed every argument the defense had made, acknowledged every legal principle they'd cited. And then he explained, point by point, why those principles led to this specific conclusion in this specific case. He talked about Miller versus Alabama, said the Supreme Court was absolutely right that youth matters, that adolescent brains are different, that courts must consider the possibility of rehabilitation. But Miller didn't require lenient sentences. It required individualized consideration. And when you actually did that individualized consideration, when you looked at Philip Chisum specifically rather than teenage murderers generally, a very clear picture emerged. The judge walked through the evidence again, not for drama, for documentation. He wanted the appellate record to show exactly what factors he'd considered and why they mattered. The gloves represented planning. The box cutter represented preparation. The surveillance footage showed deliberate movement and concealment. The stop at Wendy's showed consciousness of guilt and ability to present as normal immediately after extreme violence. The movie theater showed continued calculated behavior hours later. Every single one of those actions contradicted the defense's narrative of an impulsive, confused teenager. Every single one suggested someone who knew exactly what he was doing before, during, and after. The brain science was real, but it didn't explain this behavior. Developmental immaturity didn't explain this pattern. Judge Loey addressed the psychological evaluations next, acknowledged that Philip had experienced family disruption, that his parents' separation had been difficult, that he'd been diagnosed with mental health issues. But he also noted what the prosecution's experts had documented: the callous, unemotional trait profile, the flat effect, the absence of observable remorse across 2 years of proceedings. And then he referenced the smirk, said it directly. During victim impact statements, while Mrs. Ritzer was speaking about her murdered daughter, the defendant displayed a visible expression of contempt. That wasn't a nervous reaction, wasn't a misunderstood emotional response. It was exactly what it looked like. And it told the court everything it needed to know about whether Philip Chisum had the capacity for the kind of insight and remorse that rehabilitation requires. The gallery was absolutely silent. Some people were crying quietly. Colleen's father had his arm around his wife, both of them staring straight ahead at the judge, listening to every word. This was what they'd waited for. Not vengeance, just acknowledgement. Recognition that their daughter's life mattered, that the person who took it couldn't hide behind his age and expect the system to treat it like a youthful mistake. Judge Loey was giving them that. Was saying clearly that Colleen Ritzer deserved better than what happened to her. And the law demanded that Philip Chisum face consequences that matched the severity of what he'd done, not because he was irredeemable, but because nothing in his behavior suggested he understood what he'd done or cared about the harm he'd caused. The judge addressed rehabilitation directly. Said the possibility of change is real, that people can grow. That 40 years is a long time, and Philip would have opportunities for treatment, education, and reflection. If he used that time well, if he developed genuine insight and remorse, if he demonstrated capacity for change, then a parole board decades from now could consider whether he'd earned a second chance. But that consideration would happen only after he'd served a sentence that reflected the gravity of murdering a teacher in a school bathroom with premeditation and no provocation. The law didn't require the court to assume rehabilitation would happen. It required the court to leave room for the possibility. 40 years left that room. But it didn't pretend that possibility was the same as certainty. Judge Loey finished his remarks by speaking briefly about Colleen Ritzer, about the teacher she was, the students she'd helped, the life she'd been building. He noted her final Twitter post, the message about being good to people, said those words represented everything Philip Chisum's actions had destroyed. A young woman who believed in kindness, who stayed late to help struggling students, who'd welcomed Philip into her classroom and tried to support him during a difficult transition. She'd done nothing to deserve what happened to her. Nothing. And while no sentence could bring her back or truly make this right, the law required the court to respond with a sentence that honored her life and acknowledged the full weight of what was taken. The formal sentencing was entered into the record. Philip Chisum stood while the clerk read the specifics. Life with parole eligibility after 40 years on the murder charge. Consecutive sentences on the other counts. He showed no reaction, no emotion. Just stood there the same way he'd sat through the trial. His attorneys had already started planning the appeal before he was even transported out. They'd argued the sentence was too harsh, that the judge hadn't properly applied Miller. That 40 years was effectively life without parole, given Philip's age. They'd make those arguments knowing they were facing an uphill battle. Judge Loey had been meticulous, had addressed every possible appellate issue in his remarks, had documented his reasoning so thoroughly that overturning it would require finding legal error, and not just disagreeing with the outcome. Court officers approached Philip, placed him in handcuffs, led him toward the side door that would take him back to holding and eventually to the state prison where he'd spend the next several decades. As he walked past the gallery, past Colleen's family, he didn't look at them, didn't acknowledge them, just kept his eyes forward and walked through that door. And as it closed behind him, Tom Ritzer exhaled. A long, slow breath. Peggy beside him wiped her eyes. It was over. Not the grief, never the grief. But this part, the legal chapter that had consumed 2.5 years of their lives. The court had spoken, and for once, justice felt like the right word for what had just happened. In the weeks after sentencing, the case became required reading in criminal psychology programs across the country. Not just because of the violence, not just because of Philip's age, but because of what his behavior revealed about a specific type of juvenile offender that challenges every assumption people make about teenage crime. The smirk became the focal point. That single expression during victim impact statements told a story that hours of testimony and psychological evaluations had tried to explain in clinical language. It showed something raw and undeniable. Philip Chisum didn't feel remorse, wasn't suppressing guilt, wasn't struggling with shame. He simply didn't care. And that absence of caring was more significant than any single piece of evidence from the crime itself. Dr. Paul Frick, one of the leading researchers on callous unemotional traits in adolescents, wrote about the case in a peer-reviewed journal. He'd studied thousands of young offenders over decades of research, tracked them through childhood and into adulthood, and what he'd found was consistent and disturbing. Youth with callous unemotional traits don't respond to traditional rehabilitation the way other juvenile offenders do. They don't develop empathy through therapy sessions that work for most teenagers. They don't feel motivated by the pain their actions caused because they don't emotionally register that pain as meaningful. It's not that they're incapable of learning. They're incapable of caring. And that fundamental difference makes them far more dangerous than impulsive teenagers who commit violence in moments of poor judgment. Philip's flat effect throughout the trial fit the profile perfectly. Most defendants show some emotional response during proceedings. Fear when evidence is presented, distress during victim testimony, relief or despair at verdict. But Philip showed none of that. Court observers described him as watching the trial like someone observing a documentary about events that happened to someone else. Detached, analytical, present but not connected. That wasn't immaturity, wasn't confusion. It was exactly what the clinical literature describes as the hallmark of callous unemotional traits. An inability to emotionally engage with other people's suffering. The prosecution's psychological experts had testified about it. But the smirk made it visible in a way that no clinical assessment could. The comparison to other juvenile murder cases highlighted how unusual Philip's case was. Most teenage killers show remorse eventually. Maybe not immediately. Maybe not during trial when their lawyers advise them to stay controlled. But at some point, usually during sentencing or in the years after, something breaks through. They cry. They apologize. They demonstrate some awareness of what they've done. Philip never did. Not during the 2 years between arrest and sentencing. Not during victim impact statements when he had nothing to lose by showing emotion. Not during the judge's remarks when he had to know a harsh sentence was coming. The absence of any emotional response across that entire timeline wasn't strategic. It was diagnostic. It told clinicians exactly what they were dealing with. The premeditation aspect made Philip's profile even more concerning to experts. Callous unemotional traits alone don't predict violence. Plenty of people lack empathy and never hurt anyone. They just move through life emotionally disconnected. But when those traits combine with predatory behavior, when someone who lacks empathy also actively plans violence, the risk profile changes dramatically. That's what the gloves represented. The box cutter, the surveillance of Colleen's schedule. Philip wasn't just unable to feel Colleen's pain, he was willing to cause it, planned to cause it, and executed that plan with the kind of methodical precision that destroyed any argument about teenage impulsivity or poor decision-making. Researchers studying the case noted how Philip's post-crime behavior fit patterns seen in adult psychopathic offenders rather than typical juvenile delinquents. The stop at Wendy's, the movie theater, the calm walk along Route 1. Most teenage killers panic after a murder, run, hide, break down. He shows some sign that they're overwhelmed by what they've done. Philip showed the opposite. He moved through the evening like someone who'd completed a task and was now managing the aftermath. That level of emotional control immediately after extreme violence is rare in adults. In a 14-year-old, it's almost unheard of. And it suggested that whatever was different about Philip's psychological makeup, it wasn't going to resolve with time or therapy designed for typical adolescent behavioral issues. The question that haunted clinicians reviewing the case was whether Philip could ever develop genuine empathy, whether 40 years in prison might eventually produce the emotional growth that 2 years of legal proceedings hadn't. The research offered mixed answers. Some studies suggest that callous, unemotional traits can diminish with intensive intervention if started early enough. But Philip wasn't getting intervention at 8 or 10. He was going to adult prison at 17. The environment there wasn't designed for rehabilitation of emotional development. It was designed for containment, for punishment, for managing dangerous people in a controlled setting. Could someone with Philip's profile develop empathy in that environment? The experts didn't know. Nobody really knew. Because the research on long-term outcomes for juvenile offenders with severe callous unemotional traits was limited. There simply weren't that many cases to study. What the research did show clearly was recidivism risk. Juvenile offenders with callous unemotional traits who show predatory violence patterns have among the highest rates of reoffending once released. Higher than juvenile offenders with conduct disorder alone. Higher than those with substance abuse issues. Higher than those who committed crimes during periods of psychological distress. The reason was straightforward. You can treat impulsivity. You can address substance problems. You can teach coping skills for emotional regulation. But you can't easily teach someone to care about other people if that capacity is fundamentally absent. And without that capacity, the motivation to avoid hurting others doesn't exist. Fear of consequences can create behavioral control, but it doesn't create conscience. Philip's behavior suggested he was calculating consequences from the beginning. Wore gloves to avoid fingerprints, disposed of evidence to avoid detection. He understood punishment. He just didn't care about the harm he was causing. The smirk would be studied in criminal psychology courses for years. Shown to students as an example of visible, callous, unemotional traits in a courtroom setting. Discussed in academic papers about risk assessment. Referenced in debates about juvenile sentencing policy. Because that single moment captured something that hours of clinical testing and evaluation tried to measure indirectly. It showed the absence of empathy in real time, in a context where showing empathy would have been tactically advantageous for Philip, where his lawyers desperately wanted him to show remorse, where the judge was watching specifically for signs of insight and growth. And Philip couldn't manage it. Not wouldn't, couldn't, because the emotional capacity simply wasn't there. And that absence, more than his age or his brain development or his family history, was what made him dangerous. What made the judge's 40-year sentence not just legally justified, but psychologically necessary. The appeal was filed within weeks of sentencing. Philip Chisum's attorneys argued multiple grounds. That the sentence was unconstitutionally harsh for a juvenile offender. That Judge Loey hadn't properly applied the Supreme Court's Miller framework. That 40 years before parole eligibility was effectively life without parole, given Philip's age. That certain evidence had been improperly admitted at trial. That the psychological evaluations hadn't been given sufficient weight. The appeal brief was thorough, professionally written, and grounded in legitimate legal arguments. It did everything a defense attorney is supposed to do for their client. Fight every possible angle. Challenge every possible ruling. Make the appellate court justify every aspect of the conviction and sentence. The Massachusetts Appeals Court reviewed the case first, took months to read the trial transcripts, review the evidence, consider the legal arguments. In 2019, they issued their ruling. Conviction affirmed. Sentence upheld. The court found that Judge Loey had conducted exactly the individualized consideration Miller required, had addressed Philip's youth, had considered the brain science, had evaluated the possibility of rehabilitation, and had grounded his ultimate sentence in specific findings about Philip's behavior that went beyond categorical assumptions about teenagers. The appeals court noted that Miller doesn't require lenient sentences. It requires thoughtful ones. Judge Loey's sentence was thoughtful, detailed, legally sound. The appeal was denied. Philip's attorneys appealed to the Massachusetts Supreme Judicial Court. This was the final level of state review. The highest court in Massachusetts would have the last word on whether Philip's sentence violated constitutional protections for juvenile offenders. The case was argued in 2024. Both sides presented oral arguments before the 7 justices. The defense emphasized Philip's age at the time of the crime. 14. A child by any definition. Argued that 40 years was effectively a death sentence. That no 14-year-old should face that kind of time regardless of what they'd done. The prosecution responded with the evidence. The planning. Are the gloves? The weapon? The lack of remorse? The smirk? Ask the court whether Miller required them to ignore all of that just because Philip was young. The Supreme Judicial Court issued its ruling in February 2025. Nearly 9 years after the original sentencing, the decision was detailed and unanimous. Conviction and sentence affirmed. The court wrote that Judge Loey's sentencing remarks demonstrated exemplary application of Miller's requirements, that he'd considered Philip's youth seriously and thoroughly, that he'd evaluated the specific characteristics that made youth generally mitigating and explained why those characteristics didn't apply with the same force in this specific case. The court noted the smirk specifically, said it was appropriate for the judge to consider courtroom behavior as evidence of remorse or its absence. That observable conduct during proceedings is part of the record and relevant to sentencing decisions. Philip Chisum had exhausted his state appeals. The sentence would stand. For the Ritzer family, each appeal had been another wound reopened, another round of waiting, another period of wondering if the justice they'd finally received would be taken away by a higher court deciding Philip deserved another chance. Each ruling that affirmed the conviction and sentence brought relief, but also exhaustion. 9 years of legal proceedings. 9 years of Philip's attorneys arguing he'd been treated unfairly. 9 years of having to relive October 22, 2013 every time a new brief was filed or oral arguments were scheduled. Tom and Peggy Ritzer attended some of the hearings. Not all. Sometimes it was too much. But they wanted the courts to see them, to remember that Colleen had been real, had been loved, had mattered. The foundation they'd established in Colleen's name had grown significantly by 2025. The Colleen Ritzer Memorial Scholarship had helped dozens of students pursue education degrees. Kids who wanted to be teachers like Colleen, who'd been inspired by her story, or by teachers in their own lives who embodied the same kindness she'd shown. The foundation also funded classroom supplies for teachers in underserved schools, supported anti-bullying programs, promoted kindness initiatives. Everything tied back to Colleen's core belief: be good to people. That message, posted on her Twitter the morning she died, had become the foundation's motto, had been printed on T-shirts and bumper stickers. May had been quoted in graduation speeches and classroom posters. Colleen's words were reaching more students dead than she'd ever taught alive. Philip's time in prison hadn't gone smoothly. That was the other part of the aftermath. In 2017, he was involved in an assault on a corrections worker, a female staff member at the facility where he was housed. The incident resulted in additional charges, another trial, another conviction. More time added to his sentence. The details were disturbing enough that they weren't fully released to the public. but the fact of it confirmed what Judge Loey's sentence had anticipated. Philip Chisum remained dangerous, remained willing to use violence. The pattern that began with Colleen Ritzer hadn't ended with her murder. It had continued. And the correction system had documentation now that Philip posed an ongoing risk even in a controlled environment. The additional conviction strengthened the prosecution's original argument retroactively. They'd said Philip wasn't just a confused teenager who'd made a terrible mistake, that he represented a specific type of offender whose violence was predatory and likely to continue. The defense had argued that was speculation, that Philip deserved a chance to prove he could change. The assault on the corrections worker proved the prosecution had been right. Philip was in prison with access to mental health services, with years to reflect on what he'd done, with every incentive to demonstrate good behavior. And he'd still committed violence against a woman in a position of authority. The parallels to Colleen Ritzer's murder were obvious and deeply disturbing. The legal community studied Judge Loey's sentencing decision as a model for how to handle juvenile offender cases post-Miller. Law schools taught it. Prosecutors cited it in their own cases. Defense attorneys studied it to understand what arguments had failed and why. The decision hadn't rejected the science on adolescent brain development. It had integrated that science with behavioral evidence and come to a conclusion that was legally sound and factually grounded. It showed that Miller's framework could accommodate serious sentences for serious crimes when the individualized consideration actually supported that outcome. Judge Loey had threaded a difficult needle, applied juvenile justice principles without letting them override evidence. And every appellate court that reviewed his work had agreed he'd done it correctly. The case became landmark precedent, not because it was harsh, but because it was thorough. And in the law's long memory, thoroughness matters more than any individual outcome. The thing about grief is that it doesn't end. It changes shape, becomes something you carry differently over time. But it never disappears. The Ritzer family learned that in the years after Colleen's death, learned that you can build a life around a loss without ever really moving past it. Tom and Peggy didn't try to move past it, they moved forward with it, carrying Colleen with them in everything they did. The foundation wasn't just a memorial, it was a continuation, a way of keeping their daughter's impact alive in the world. Every scholarship awarded, every classroom supplied, every student helped. It was Colleen's hand still reaching out, still teaching, still making a difference. The students who'd been in Colleen's classroom during her 2 years at Danvers High grew up carrying her with them too. They graduated, went to college, started careers. Some became teachers themselves. And when they did, they talked about Ms. Ritzer, about how she'd made them feel seen, how she'd stayed late to help them understand concepts that felt impossible, how she'd believed in them when they didn't believe in themselves. One former student, interviewed 10 years after the murder, said Colleen had changed the entire trajectory of her life. She'd been failing algebra, convinced she was stupid, ready to drop out. Colleen spent 3 months of Friday afternoons working with her one-on-one until math finally clicked. That student went on to graduate high school, attended community college, eventually became a nurse, said none of it would have happened without Ms. Ritzer refusing to give up on her. Danvers High School created a permanent memorial for Colleen, a reading area in the library named in her honor, decorated with quotes she'd loved, stocked with books about teaching, kindness, and making a difference. Students could go there during study periods or free blocks. Sit quietly, read, reflect. The space was designed to feel like Colleen's classroom had felt, welcoming, safe, a place where struggling students knew they'd find support instead of judgment. Teachers brought their classes there sometimes for special lessons about empathy and community, about what it means to be the kind of person who stays late to help, who notices when someone's struggling, who chooses kindness even when it's not required. The national conversation sparked by Colleen's murder led to real policy changes. School security protocols were reviewed and updated across Massachusetts, not just at Danvers High, but statewide. Questions were asked about how a student could follow a teacher into a bathroom and commit murder without anyone noticing until it was too late. The answers were complicated. Schools can't function like prisons. Teachers can't live in fear of their students. But there were reasonable improvements that could be made. Better security camera coverage, protocols for teachers working alone after hours, training on recognizing warning signs in student behavior. None of it could bring Colleen back, but it might prevent the next tragedy. And that mattered. The broader discussion about juvenile offenders with callous, unemotional traits gained momentum after Phillips' case. Researchers received increased funding to study early identification and intervention. Mental health professionals developed screening tools to identify at-risk youth before violence occurred. The goal wasn't to label kids as future criminals. It was to get help to children who showed warning signs early enough that intervention might actually work. Because the research was clear. By the time someone like Philip Chisum commits murder at 14, the window for effective intervention has likely closed. But at 8 or 10, with intensive therapy and family support, outcomes could potentially be different. Philip's case became a cautionary tale about what happens when warning signs go unrecognized or unaddressed. Colleen's Twitter account remained active years after her death. Her family kept it up as a memorial, the last post still visible at the top. No matter what happens in life, be good to people. Being good to people is a wonderful legacy to leave behind. Thousands of people had liked and shared that post over the years. Teachers used it in their classrooms. Parents showed it to their children. It became one of those quotes that circulates during difficult times. A reminder of what matters, of who we should aspire to be. Colleen had posted it casually the morning of October 22, 2013. Just another encouraging message for her students. She had no idea it would become her final public words. No idea those words would outlive her by decades and reach millions of people she'd never meet. The scholarship program bearing Colleen's name had awarded over 50 scholarships by 2025. 50 future teachers who might never have afforded their education without that financial support. Each recipient received not just money, but a letter from the Ritzer family, telling them about Colleen, about what she believed, about the kind of teacher she'd been, asking them to carry that forward, to be the teacher who stays late for struggling students, who creates a classroom culture of kindness, who sees potential in kids everyone else has written off. Many of those scholarship recipients wrote back, shared their own stories, promised to honor Colleen's memory by becoming the kind of educator she'd been. The foundation had created a network, a community of teachers connected by Colleen's legacy and committed to living out her values. Tom and Peggy Ritzer aged visibly in the decade after losing their daughter. The grief and stress left marks that couldn't be hidden, but they also aged with purpose. Every year they hosted a memorial run in Colleen's honor. Hundreds of people participated, former students, teachers, community members who'd never met Colleen but had been moved by her story. The event raised money for the foundation. But more than that, it created space for collective remembering, for a community to come together and say this loss mattered. This person mattered. We won't forget. Tom would speak at every event. His voice still broke when he talked about his daughter, but he talked anyway, shared memories, told stories, made sure people understood that Colleen wasn't just a name in a news story. She'd been his little girl, his daughter who'd wanted to be a teacher since she was 8 years old and had made that dream real. The truest measure of a life isn't how long it lasts. It's what it leaves behind. Colleen Ritzer lived 24 years, taught for 2, and in that brief time created ripples that would reach farther than she could have imagined. Students whose lives she'd changed, teachers she'd inspired, a foundation that would help future educators for generations, a message about kindness that refused to be silenced even by the violence that took her voice. Philip Chisum had tried to erase her, had planned her murder, had shown no remorse for what he'd taken. But he'd failed in the most fundamental way, because Colleen's impact wasn't erased. It multiplied. And the world was better for having had her in it, but even for too brief a time. The story of Philip Chisum and Colleen Ritzer didn't end in a courtroom. It continued in law schools, where Judge Loey's sentencing decision was studied and debated. In psychology programs where Philip's case became a textbook example of callous, unemotional traits and predatory violence in adolescence. In schools where teachers received training on recognizing warning signs. In scholarships awarded to future educators. In a foundation that turned grief into purpose. The legal chapter closed when the Massachusetts Supreme Judicial Court affirmed the sentence. But the human chapter, the one that mattered most, was still being written by everyone who refused to let Colleen's death define her more than her life had. Judge David Loey's ruling stood as a landmark in juvenile justice, not because it was harsh, because it was careful, because it showed that taking youth seriously as a mitigating factor doesn't mean ignoring evidence of who a specific young person is and what they're capable of. The Supreme Court's Miller decision had been right, that adolescent brains are different, that kids deserve different treatment than adults. But Miller had never said that all juvenile offenders are the same, that youth automatically overrides every other consideration. Judge Loey had done exactly what Miller required. He'd looked at the individual, and what he'd seen was a 14-year-old who wore gloves to murder his teacher, who showed no remorse across years of proceedings, who smirked while her mother grieved. That wasn't immaturity. That was something else entirely. The sentence itself, life with parole eligibility after 40 years, I achieved something important. It held Philip accountable for the calculated violence he'd committed. But it also left room, however distant, for the possibility of change. If Philip spent the next 4 decades developing genuine insight and remorse, if he engaged with treatment and demonstrated real growth, a parole board in 2056 could consider whether he'd earned release. But that consideration would happen only after he'd served serious time for a serious crime. The sentence didn't give up on rehabilitation. It just refused to assume rehabilitation was inevitable, or that 40 years was too long to wait before making that judgment. Philip Chisum would be 54 years old when he first became eligible for parole. By then, the teenager who'd murdered Colleen Ritzer would be middle-aged, would have spent more years in prison than he'd lived before committing the crime. The parole board that eventually reviewed his case would have access to everything: the original crime, the trial transcripts, the smirk, the assault on the corrections worker, decades of behavioral records documenting how he'd spent his time in prison, whether he'd taken responsibility, shown remorse, engaged meaningfully with treatment, or whether he'd remained the same person he'd been at 17. Cold, detached, dangerous. That future parole hearing was decades away, but it would be thorough, and it would be guided by the complete record of who Philip Chisum had proven himself to be. The Ritzer family would be there for that hearing if they were still alive, still advocating for Colleen, still making sure the parole board understood what Philip had taken. Tom Ritzer would be in his 80s by then, Peggy too. Their other children would carry the responsibility if their parents couldn't. The family had committed to making sure Colleen's voice stayed in the room every time Philip Chisum's name came up for review, every time someone considered whether he deserved freedom. They'd be there to remind the board about the teacher who stayed late to help students, who posted messages about kindness, who'd done absolutely nothing to deserve being murdered in a school bathroom. The family wouldn't seek vengeance. They'd just seek truth. And the truth was that some crimes are so calculated and show so little remorse that 40 years is appropriate before even considering the possibility of release. Oh, the case changed conversations about juvenile justice across the country. Defense attorneys still cited brain science and argued for rehabilitation. Prosecutors still pointed to Philip Chisum when arguing that some young offenders pose serious ongoing risk. The debate would continue, but it would continue with better nuance, with recognition that juvenile offender isn't a monolithic category, that a 15-year-old who commits assault during a fight is psychologically different from a 14-year-old who wears gloves to murder his teacher, that courts can take youth seriously while also taking evidence seriously, that mercy and accountability aren't opposites. They're different aspects of justice that have to be balanced case by case, individual by individual. Colleen Ritzer's legacy outlived Philip Chisum's crime. That's the final truth of this story. He'd tried to take everything from her, succeeded in taking her life, but failed to take her impact, failed to erase what she'd meant to her students, failed to silence the message about kindness she'd lived by. The foundation bearing her name would continue awarding scholarships long after Philip was released, if he ever was. The students she'd taught would tell their own children about Ms. Ritzer, about the teacher who'd believed in them. The reading room at Danvers High would remain, a permanent reminder that violence doesn't get the last word. Love does, purpose does, the decision to build something good from something terrible. Judge Loey had made history with his ruling, but Colleen Ritzer had made history with her life, with 2 years of teaching that influenced students forever, with a message about kindness posted the morning she died that reached millions of people afterward, with parents who turned unspeakable loss into a foundation that would help future teachers for generations. That's the real story. Not what Philip Chisum did, but what Colleen Ritzer was, and what her family chose to do with their grief. They could have been consumed by anger, by bitterness toward the justice system, by hatred for the boy who'd destroyed their family. Instead, they chose to honor their daughter by continuing her work, by being good to people, by leaving a legacy that made the world better. The gavel had fallen. The sentence was final. Philip Chisum would spend decades in prison for what he'd done. And Colleen Ritzer's name would live on in scholarships and memorial spaces and the hearts of students who'd been lucky enough to be in her classroom. Justice wasn't just what happened in that courtroom. Justice was what happened afterward, when a community refused to let tragedy win, when a family turned grief into purpose, when a teacher's message about kindness proved stronger than the violence that tried to silence it. That's what history would remember, not the smirk, but the smile Colleen wore in every photograph, the joy she brought to teaching, the difference she made in the brief time she had. That's the legacy that mattered. That's the story that deserved to be told. If you believe that justice means holding people accountable while honoring the victims they tried to erase, share this story. Subscribe so others can find it. And leave a comment about the teachers who made a difference in your life. Because every time we remember people like Colleen Ritzer, we refuse to let the wrong person define what happened. We choose to remember the light, not just the darkness that tried to extinguish it.